Mr. Bryant, would you state your name and spell your last name for the record, please, sir?
David Allen Bryant, Bryant.
Mr. Bryant, how are you employed, sir?
I am the Vice President of Analytics at Ironwood Insights Group.
And what is Ironwood Insights Group?
It's a full-service marketing research firm based in Arizona.
Okay, and you were retained to do a survey regarding the Lori Vallow, Chad Daybell case. Is that correct?
Correct.
And what steps did you take as part of your process to conduct that survey?
Well, the first thing I did was I did a literature search on media so that I was aware of all of the various names and people associated with this case. I then developed the questionnaire, and that questionnaire was sent to Mark Means. I don't know if he shared it with you or not, Mr. Pryor, but we then received some corrections back on the questionnaire. Once that was approved, we then programmed the questionnaire for both telephone and internet. And we administered that survey between February 15th and February 28th earlier this year in 2021.
Okay, let me talk a little bit about your experience in conducting these sorts of surveys. Can you provide us some background information in terms of your experience in doing these sort of things?
Yes, I have been doing marketing research, survey research, polling research since 1980, when I originally started working for Dr. Richard Worthland, who was Ronald Reagan's pollster. So I've been doing this for over 40 years and analyzing statistics and designing questionnaires and preparing reports based on those survey results.
So you have done this for a significant amount of time, have a significant amount of experience. Is that a fair assessment?
Well, I like to think so, yes, 40 years.
Is there anything that, as part of this survey, that you deviated from in terms of the standards that are put upon people who conduct surveys in your particular business?
No, we adhere to the standards of APOR, the American Association of Public Opinion Research, and the Insights Association. These are standards for maintaining confidentiality of respondents and the way the survey was developed. It's developed to be unbiased in terms of its questions and the sequence of the questions. And so, no, we strove to adhere to the highest standards, which is, in my opinion, the APOR standards, the American Association of Public Opinion Research.
Now, previously, last week, you provided me a copy of the study and the questions. Is that right?
Correct.
And Judge, those questions in that study were submitted to the court as exhibit. I believe it's exhibit number 10. You and I discussed the Ironwood Insights report. We discussed the survey, and the copy you provided to me was a true and accurate copy of the survey that was conducted in this particular case. Is that correct?
Correct.
Judge, I would move for admission of the Ironwood Insights report and survey. That's marked in the booklet that I provided to counsel and to the court and to your clerk as exhibit number 10 in my notebook.
All right.
Your Honor, the state of Jackson would like to ask some questions in aid of objection.
All right, go ahead.
Thank you. Mr. Bryant, I'm not going to get into any of the specific findings of your survey as I ask these questions, but I do have a few questions. You did say that you provided an initial questionnaire to Mark Means and he provided corrections. Is that true?
Yes.
Mr. Bryant, are you familiar with the standards set forth by the Pittsburgh Press Club versus United States case for admitting surveys and polls into evidence?
No.
Okay. Are you aware that when a survey is supposed to be admitted into evidence, that the survey must be conducted independently of the attorneys involved in the litigation?
No,
Okay. I want to ask you a couple other questions. Go to the admissibility. Again, I'm not going to ask you any of the substance of the survey. In your survey, how many counties did you conduct a survey in?
4.
What were those counties?
Bonneville, Fremont, Jefferson, and Madison.
Okay, and what percentage of the people surveyed were in Fremont County?
Judge, we're going beyond the scope of his objection. At this point, he's questioning my witness.
This goes directly to admissibility.
All right. And before you jump in, counsel, give me an opportunity if there's an objection. The issue here is admissibility. Exhibit 10's been offered. There's been an objection. Without getting further into cross-examination, which this is becoming, Mr. Wood, what is the grounds for the objection to Exhibit 10?
This poll is irrelevant, Your Honor.
And what's that based on?
This poll is a combination of a survey of Bonneville, Fremont, Jefferson, and Madison County. We are here today for the sole purpose of determining whether or not Fremont County is an appropriate venue. And yet this poll does not provide survey results simply for Fremont County. It's a combined poll. Now, Mr. Bryant may have had a reason at the time to do that. However, we're not here today to determine if Bonneville, Madison, Fremont, and Jefferson combined can provide a fair and impartial jury, just Fremont County. And so where this poll has all these other results from other counties, almost 90% of the results are from other counties. And it's not divvied out by county. This poll is irrelevant this survey and report are irrelevant to today's proceedings.
All right,
Also, this poll does not meet the standards met and Mr. Pryor has not even made an effort to lay the foundation required by Pittsburgh Press Club versus United States. So there's also a foundation objection.
All right, your response to those objections, Mr. Pryor.
Judge, to suggest that I'm supposed to limit my survey to one particular county is ridiculous. And to suggest if he wants to make the argument that because Fremont was only a portion of this survey, that the results are invalid, I'll be dealing that with Mr. Bryant. As far as the Pittsburgh case that he refers to, Judge, the survey, if you read the case, it says that the attorney is involved in the actual polling. The attorney's intimately involved in the case. To suggest that Mr. Means or myself cannot make suggestions to Mr. Bryant in terms of what areas we would like to explore for purposes of a survey is absolutely ridiculous. And Mr. Bryant's going to address those.
All right, there's a pending objection. Counsel, I'm going to take this under advisement for just a minute and review that case. I've seen the case, but I haven't read it recently. So I'm going to take a moment, take a look at that. After I've reviewed that case, I'll come back on and make a ruling on the objection as to foundation. All right, counsel, we'll be back on the record here. The court has considered an objection to the admission of defendants Exhibit 10. The state cited the Pittsburgh Press Club case. Courts reviewed that, which raises the issue of whether or not a survey would be admissible if it is material, if it's more probative on an issue than other evidence and has circumstantial guarantees of trustworthiness equivalent to those of the class exceptions they talked about in that case. And then the proponent of admitting that has the burden of establishing the elements of the admissibility. So at this point, the objection was based on relevance and foundation. On the relevance issue, I do find that for purposes of this hearing, there's been a foundation, it's been established that it may be relevant subject, of course, to cross-examination if Mr. Wood believes there's issues with the way it was conducted. In terms of the foundation, at this point, I would indicate, Mr. Pryor, I don't believe there's been a sufficient foundation laid for the admission of that, but I'll allow additional foundational questions if you have those from your witness before making a final ruling.
Okay. And Mr. Bryant, I want to start again. Can you hear me, sir?
Yes. Can you hear me?
Yes. So at this point, the survey that was conducted by your organization was done in the ordinary course of your business from your company. Is that correct?
Yes.
And nothing deviated from the standard procedures that you applied and the standards that are set out by your trade and organization. Is that correct?
Correct.
And you conducted the survey. Now, in regards to the questions, ultimately, Mr. Means did provide you some suggestions, but ultimately you formatted and put together all the questions yourself through your organization. Is that right?
Yes.
And then those questions were transmitted out on a variety of medium. Is that correct?
Correct. Both. We conducted the survey by telephone and by internet, by an invite to a web survey.
Now, based on the size of this survey, and before we get into that, when we're talking about the percentage of error or the percentage that would apply to a particular survey such as this, how much of a percentage of error or a deviation is there on a survey such as this?
The traditional explanation in a beginning statistics class is you assume that responses are 50-50, 50% said yes to this or 50% said no. So based on that 50-50, we had a total of 177 completed surveys, which yields a sampling error of plus or minus 7.3%. That table is actually included at the end of the report. As you move towards further extremes, as numbers become 60-40, 70-30, 80-20, and so on, then that sampling error becomes smaller and smaller.
Well, that brings up an interesting point, is that part of the questions and part of this survey was to decide and find out what people's feelings were regarding the Chad Daybell Lori Vallow case, correct?
Yes.
And one of the questions obviously was whether or not people in the survey thought that Mr. Daybell or Ms. Vallow were guilty. Is that correct?
Correct.
And the percentage.
Objection, we're getting into the substance of the poll without it being properly admitted.
I don't need to admit it yet.
Well, if we're going to testify off of it and the results, then it's been offered and we need to get a ruling on the admissibility. So I've allowed for additional foundation. Do you have any additional argument on the objection to the admission of that survey, Mr. Wood?
Yes, Your Honor. There are 7 factors that Pittsburgh requires. So far, Mr. Pryor has, I do believe he has established Mr. Bryant as an expert. However, he has not met any of the other requirements. In fact, he has, I would argue, actually gone against some of those requirements. And so we still object. He has not laid the proper foundation for this poll or the results to be admitted into court.
All right. At this point, I have considered that objection in light of that Pittsburgh Press Club case. I would note that the question here is not ultimate admissibility at trial for either a jury or a court to consider on the ultimate issue that may go to the results of the survey, as was the case in there. This is a hearing as it relates to argument regarding publicity in a venue motion. And so based on the context of where we are, the court does find that for purposes of this hearing only, the survey will be admissible, of course, subject to cross-examination, Mr. Wood, if you have an issue with the way it was conducted. So the court will allow the admission of exhibit number 10, and that will be admitted into the record.
Thank you, Judge. May I continue?
You may.
And Mr. Bryant, so we were on the subject. I'm sorry, I just had a hesitation there. Mr. Bryant, we were on the subject of the survey that was conducted in this particular case. And one of the areas of the survey addressed the issue of whether or not the people who responded to the survey felt that Mr. Daybell or Ms. Vallow were guilty. And can you talk a little bit about the response that you elicited from the survey?
Yes, the specific wording of the question was, and this is question 9, if you were to say you lean one way or the other right now about the guilt or innocence of Lori Vallow Daybell and Chad Daybell, which way would you lean? Now, from the 177 respondents, we had 82.4% said they were guilty.
Okay.
And only one person said they were innocent. We had we had 3.4% said they were innocent until proven guilty, and 11.4% said that they needed more information before they were able to answer the question.
Okay. Now, in applying the margin of error on this particular question, 82%, what is the range of possibility? You had previously discussed that as you get higher up in the level of percentage. Now, we're talking a situation where 8 out of 10 people from Madison, Fremont, Bonneville, and Jefferson County determined 80% of those people in the survey from those particular counties determined that Mr. Daybell and Ms. Vallow were guilty. What's the margin of error? How high could that number actually be, given the margin of error that you would, from your experience, apply in this particular case?
Your Honor, I'm going to object to relevance where, again, this doesn't just apply to Fremont County, and we're dealing with multiple other counties.
Judge, you've already ruled on that. Can I go forward, please?
I'll overrule that objection. Go ahead.
Again, sir, what is the margin of error when we're talking about 8 out of 10 people, more than 8 out of 10 people already determining in this particular district that Mr. Daybell is guilty? What's the margin of error, sir?
5.8%.
So if we apply the 5.8 to the 82 point, what percent?
82.4.
Now my math may be a little off, but I come up with 88% given the high end of the margin of error. Is that fair?
Sure.
Okay. Well, 5.8 plus 8.4 is
Well, 82.4 plus 5.8, yes.
In north of 88% of the people believing that Mr. Daybell is guilty. Is that fair?
Yes, but it also goes the other way. It goes.
And I'm going to talk about that. It can go the other way as well. It could go down to 77 or 76 point something percent, correct?
Correct.
Now, in your experience, and you talked about over 40 years doing this, how often have you run into a poll that was so slanted in one particular direction?
Well, it does occur. If you ask someone how satisfied they are with their new car, 82% might say they're very satisfied with their car. In this case, this is a very large percentage of people who believe that Lori Vallow Daybell and Chad Daybell, well, they lean towards their guilt.
Okay. Now
It's a very high percentage, yes.
So you would consider this a very high percentage?
Yes.
Okay. Now, one of the other questions applied to whether or not Ms. Vallow and Mr. Daybell could get a fair trial, correct?
Correct.
Now, taking into consideration that over 82% believe that Mr. Daybell is guilty, one of the other questions you asked is whether or not he could get a fair trial. What were the responses in regard to that?
Well, we had 22.6% said that they definitely will receive a fair trial in Fremont, Madison, Bonneville, or Jefferson County. And an additional 37.3% said that they probably will, which is a total of 59.9%, almost 60%, or 6 out of 10 respondents felt that they would receive a fair trial in one of those 4 counties.
Okay. So I'm a bit confused. 82% say that he's guilty, but in spite of being guilty, he'll still get a fair trial. Is that what the polling seems to suggest from the folks in Jefferson, Fremont, Madison, and Bonneville County?
Correct.
Okay. Now I want to talk about particulars by way of county, and Mr. Wood brought this up. What are the percentage of respondents from Bonneville County?
55.4% of all the respondents were from Bonneville. Obviously, that's where we were able to get the most respondents.
And obviously, that's a significant population in Bonneville County as well, correct?
Correct.
We're talking somewhere around 120,000 plus people, correct?
I can't verify that. Sorry, I didn't verify those numbers before getting on this.
And obviously, if you're talking about Boise, you're talking about a market it's not as big of a market as you would find 500,000 people in the Boise market, correct?
Well, that's correct.
Objection assumes facts, not in evidence.
Sustained. I'll strike that answer.
Okay. So at this point, what were the percentage of Fremont County?
We were only able to obtain 10.2% of our 177 respondents. So about 18 people were from Fremont County.
Does that change your factors in terms of the margin of error any?
Well, not on the overall survey responses of 177, no, but if we had to just analyze the 18 people in Fremont County, yes, it would create very large sampling errors.
Right, right. So the idea is not just to limit yourself to Fremont County. The idea is to get an overbroad spectrum of people from a variety of areas to get a more accurate polling of what people's beliefs are. Would that be fair?
Yes.
Okay, so what did we do in Jefferson County? How many people over there?
Well, we received 15.8%, about almost 16% of our 177 are there in Jefferson County.
And then how about Madison County?
18.6%.
Okay, so the people as a result of this survey were predominantly from Bonneville County, is that correct?
Correct. Well,
And
over 50% from
Right.
all 4 counties came from that one county.
Right. So predominantly the idea here, and obviously you're the expert in this, is to draw from a large swath of people to get a more accurate representation of how people in Eastern Idaho feel about Mr. Daybell and Ms. Vallow. Would that be fair?
Well, that was the objective, yes, to collect information from all 4 of those counties.
And the cumulative information only provides at 80%, all of the cumulative counties and the information that was obtained provides a margin of error of just a little over 5% then, is that correct?
Well, on that one question where it's 82% who said yes, they leaned towards the defendants being guilty.
Right, okay. Judge, I don't have any further questions. I'll defer to counsel at this point.
All right, Mr. Wood, cross-examination.
Thank you, Your Honor. Mr. Bryant, thanks for being here. I want to talk about the universe you chose to conduct your poll. You did state, correct, that your participants needed to be at least 18 years of age, and either have a valid driver's license or be a registered voter in Idaho living in Bonneville, Fremont, Jefferson, or Madison counties, correct?
Correct.
And you did that to make sure that the people you polled were potential jurors, correct?
Correct.
Okay. Now, I want to talk about, you said Mr. Means gave you suggestions on questions.
Yes, I wrote the question, and I have to tell you, thank you for asking that. The one big change that Mr. Means gave is he wanted to make sure that the word Vallow was included in Lori Vallow Daybell's name.
Okay, but so he did participate at some level in the creation of the questions.
Yes, I did not include Vallow in Lori Daybell's name.
And did he make any other suggestions to you?
I don't recall that he did, no.
Okay. I want to talk about your representative sample. You've said that 10.2% of the individuals polled came from Fremont County, correct?
Correct.
And that, according to my math, is about 18 people. Is that correct?
Yes, I actually have the numbers right here. Actual numbers, if you don't mind.
That would be great.
We actually have achieved 98 out of Bonneville, 18 out of Fremont, 28 out of Jefferson, and 33 out of Madison. I can repeat those if you need me to.
I've got it. Thank you. You've been conducting surveys and polls for, you said, approximately 40 years.
Correct.
How many times have you polled as to the guilt of a criminal defendant in an area where a juror could be called?
Twice before.
Twice before. So this isn't done regularly, is it?
No, I have to admit, most of my research is in healthcare, public policy.
Okay. And so in doing your poll, let me ask you this. Are you familiar with, did you study any census numbers to get the relative populations of the counties you polled?
No.
Okay. And you said that you sent an invite out for the poll online. Is that accurate?
Correct.
And so, and how did people respond to that? What was the methodology for sending that out, and how did people respond to it?
We contract with a sampling firm, specifically Dynata, which is one of the largest in the United States. They're based out of Provo, Utah. And Dynata, we requested panel sample meeting. We identified the criteria of over a certain age, driver's license, registered voter in those 4 counties. They told us how many they had where they had email addresses, and they told us how many they would have where they had telephone numbers. So when they had email addresses, we sent them an invite indicating that we were conducting a poll with residents in those 4 counties. And if we were able to get a response by web via an online survey, then we collected those. If we had both an email address and a telephone number, and they did not respond to the web invite, we then followed up with a telephone call. If all we had was a telephone number, then we started out conducting by making telephone calls.
Okay. In the email that was sent out, did it identify what the subject of the poll was?
Yes.
Okay. So someone who is interested in that issue might be more likely to take that poll, correct?
That's correct.
Okay.
I mean, we did not say it was a murder trial in eastern Idaho. We just said we're interested in your opinion about a local a court case that you may or may not have heard of.
Okay, so it didn't identify it by the words Vallow or Daybell?
No.
Okay. All right. So let's get to, we're here today, Mr. Bryant, to determine if jurors in Fremont County are able to be unbiased in a jury trial. And so as I look at your poll, I cannot read this and get information specifically about jurors in Fremont County, correct?
That is correct. Because we were I'm sorry to interrupt, but we were requested specifically by Mr. Means to conduct the survey in all 4 counties.
All right. And he did not request that you divvy that up county by county, correct?
That's correct.
Okay. And so if I want to poll and survey potential jurors in Fremont County, well, strike that. Did you do any type of county to county comparison in the numbers you received?
No, I was not requested to do that.
Okay. And I think you testified earlier, you're not familiar with the population size of Fremont County, correct?
Correct.
Okay. Really quick, was this poll conducted, do you know if it was conducted on behalf of Lori Vallow, Daybell, or Lori Vallow, Daybell, and Chad Daybell?
Wow, my understanding is that it was being conducted on behalf of both.
Okay.
That's my understanding.
Okay. And when you asked the questions in your poll about guilt, say question 9, you didn't separate Lori Vallow and Chad Daybell, did you?
No,
So again, and sorry, I kind of got off on a little bit of a tangent there, but if I want to, again, I can't look at this poll and know and separate information about Fremont County without it being combined with information from those other 3 counties.
well, I could do that, but given that we only have 18 respondents from that county, your sampling error is going to be huge. And I usually, as a rule of thumb, we don't put forth results for just anything under 25 respondents. And with only
Okay.
18 in that particular county, the numbers would have very large sampling errors.
Okay. And so would you agree with me that 18 individuals is a very small amount of individuals to poll on an issue like this?
Well, if I'm looking at just that one particular county, yes, but the objectives that were given to us from the research specifications were not to just survey just one county.
Sure, and I understand that. And the questions I'm asking are not necessarily what you were asked to do. We understand you were given a commission and that you followed that commission. I'm not questioning that. It's the applicability to Fremont County. And
well, with only 18 respondents, I would not apply the results from those 18 respondents to reflect the entire opinion of residents in Fremont County.
thank you. I have just a couple more quick questions. I would note that your question 1, it reads, are you familiar with any crimes that happened in the Rexburg area over the last couple of years where 2 or more people were killed? That's the question, correct?
Yes.
And you would agree, would you not, that the moment you say the word crime, you imply that someone's guilty, correct? Because crimes don't commit themselves.
Well, you're getting into semantics here, Mr. Wood. I guess
Okay.
that's the language I put in the questionnaire, and
Okay.
nobody objected.
Did you ever ask anybody if they believed that individuals are entitled to a presumption of innocence before proven guilty?
No, that was not the objective. However, we did have that as a response category that had been assigned to question 9.
Yeah.
When you're reading just for clarification, when you're doing a web survey, these were all what we call closed-ended questions. And so when someone saw the question 9, if you were to say you lean one way or the other about the guilt or innocence of Lori Vallow, Daybell, and Chad Daybell, which way would you lean? All the respondents saw the possible responses of guilty, innocent, innocent until proven guilty, and need more information before answering. And they had the option of saying, I don't know. So they saw those on the screen as they were conducting the survey. Similarly, if they participated in the survey via the telephone, the interviewer read those response categories to the respondent. And so there again, they heard the words innocent until proven guilty.
Okay.
Did that answer your question?
Somewhat.
Not exactly.
I understand a little more how the poll was conducted now. Based on the way these questions were asked, would you be able to separate out the bias against Chad Daybell as opposed to Lori Vallow Daybell?
No,
Okay.
I'm sorry. Yeah, the only thing that gets to that is we have, we have questions 3 and 4. Question 3, do you remember any details about this crime or the people involved? That was an open-ended question. So we didn't give them any names, but, and so you can see in question 3, 39.2% mentioned Lori Vallow Daybell, 35.2% mentioned Chad Daybell. Those are what we call open-ended questions. I didn't give them a list of options to select from. People mentioned Lori Vallow Daybell or Chad Daybell.
Okay. Now, based on your answer that you can't separate the bias totally between Mr. Daybell and Mrs. Vallow Daybell, is it also fair to say you cannot separate the bias between Mr. Daybell and Mrs. Vallow Daybell in Fremont County?
Oh, definitely not. Not from only 18 respondents, no.
So, Mr. Bryant, with the way you're answering these questions, if you were to conduct a poll for the purposes of finding if a jury could be pooled in Fremont County only, you would have wanted to question a lot more than 18 people, correct?
Well, I would have, yes. Statistical rigor, rules of APOR would have requested or would require that we had at least 100 completes just from that one county.
Okay. I just have just a couple more questions. Did you have any help in conducting the survey from people in your firm?
Absolutely, yes. I had a project manager. I had programmers who programmed the survey.
And would you consider those people that work with you to be experts?
Well, absolutely.
Okay, that suffices. I don't.
Yes.
Were you aware of the purpose of the litigation when you conducted your poll?
It was originally mentioned to us by Mr. Means that yes, this was specifically the Fremont change of venue survey.
Okay. And again, you testified earlier that you're not familiar with the United States Supreme Court case, Pittsburgh Press Club versus United States.
Judge,
No.
I'm going to object at this point. This court made a ruling on that issue, and Mr. Wood is just trying to relitigate an issue that this court already addressed.
Your Honor, I'm entitled to ask questions that go to the weight of the survey.
I'm making a ruling already, Mr. Wood. It's overruled. I think it is still relevant, so you can answer the question or you can re-ask it, Mr. Wood.
No, he did answer the question, if I'm correct, that he was aware of the purpose of the litigation, Your Honor.
And the
The
question
state this time has,
Mr. Wood, the question objected to is about the press club opinion. And I don't believe it was an answer.
well, he already testified to that, Your Honor. He wasn't aware of it. That's fine. At this time, the state has no further questions for Mr. Bryant. The state would make a second motion to exclude, though, based on Mr. Bryant's answers, that this poll for the purposes of Fremont County is simply not sufficient. I think he said he need 100 complete surveys, and there are only 18. So again, the state makes a second motion based on lack of relevance to exclude this poll.
All right, your response to that motion before we get into further redirect, Mr. Pryor.
Judge, at this point, the survey was done in a 4-county area that included Fremont County. As a whole, and as a complete whole of 170 plus 77 responses, Mr. Bryan testified that the margin of error is 5.8%. So as a whole, in counties that include Fremont, in counties that include Madison, in counties that include Jefferson and Bonneville. Now, the allegations in this case are rise out of both Madison and Fremont County. To have this court order myself or Mr. Means to do a survey in Fremont, then do a survey in Madison, then do a survey in Jefferson, and then do a survey in Bonneville would be prohibitive. So my feeling is if the court wants to apply whatever weight to this survey it wants to apply, that's the court's prerogative. And at this point, the relevant argument is inapplicable in this particular situation. It's clearly relevant.
All right, I've considered the state's second motion to exclude after the testimony of Mr. Bryant. The issue that's brought up for the court is the small number of Fremont County citizens that were polled as part of this polling, a total of 18. The issue before the court is whether or not a fair and impartial jury can be found within Fremont County. And for purposes of this hearing, which is what the Exhibit 10 is being proffered for, and the issue as it relates exclusively to Fremont County, the court does find, based on the responses of Mr. Bryant, that Exhibit 10 will not be considered both for lacking foundation and on relevance grounds, mostly based on his very candid testimony that he would not apply the results of the survey to Fremont County because the sampling error was too small and the margin of error would be potentially too large, and it would go against the standards of APOR, which are the standards he used to conduct the survey, with a result of only 18 participants on the survey. So I think clearly, having heard those responses, the court can't consider this survey as it relates to finding potential jurors in Fremont County. So the court is going to sustain that motion offered by Mr. Wood, and the survey Exhibit 10, although previously admitted, will not be considered in the court's determination on the issue.
And Judge, in response to the court, if I may, if you look at my change of venue motion, I am asking to move from Fremont County, but I specifically in my motion address the issue as it relates to the 7th Judicial District that includes Madison, Jefferson, and Bonneville counties. My motion for change of venue specifically says that this hearing and this trial could not be effectively held in the 7th Judicial District. So I would ask the court to strongly reconsider its position as, although this is Fremont County, I think the court is splitting hairs by saying, yes, Fremont County, and but frankly, I was also moving for the entire move from the 7th Judicial District. And under the rule, I'm permitted to seek a change from a particular judicial district. So at that point, based on how I've pled this in my pleadings, I think it is relevant.
Your Honor, I would just very quickly respond. This poll did not include all of the 7th Judicial District. It left out Bingham County, which is a fairly large county, and a couple of other smaller counties. So the poll would still not be relevant.
Well, Judge, you know, I don't have to go over every entire county to do this. What I do is I take the largest county within the 7th Judicial District, who happens to be Bonneville. I take the 2 counties that happen to be where a significant number of these allegations arise, and I take the adjoining Jefferson County. So when I pled this, I included the 7th Judicial District in my pleadings, and under the rule for a change of venue, a transfer, a trial, I am allowed to select and plead that this particular judicial district is not appropriate. So I renew my motion, Judge, and ask the court to reconsider and allow this exhibit to be admitted.
All right. Well, I've considered the arguments on the admissibility of this Exhibit 10. I've also considered the change of venue motion itself and Criminal Rule 21. And still the question before the court today, while Rule 21 does contemplate whether transfers should occur within the district or outside of the district, and that's part of a determination, the first question the court has to cross as a threshold before getting there is whether or not we are transferring this trial out of the current location of Fremont County. And so the issue is whether or not we could find a fair and impartial jury in Fremont County. We haven't made a determination yet that it's being transferred within the district. If it were there, potentially this would be admissible, but where we are right now is trial located in Fremont County. The first judicial question I have to get to is whether or not we're going to go outside of Fremont County, and then we'd consider where an appropriate place would be, a different county. And so based on consideration of all that, still with those responses we have and only 18 people polled within Fremont County, the court's not going to change the decision I've made that Exhibit 10 will not be admitted or considered for purposes of this motion today. So that'll be my ruling, counsel.
And Judge, I guess in my position, simply if the court is excluding the report for purposes of Fremont County, at such time, if the court decides that Fremont County is not appropriate and is looking at whether or not the 7th Judicial District is relevant, at that point, this report does become relevant at that point.
Well, that is a potential, Mr. Pryor, because under Criminal Rule 21C, under Parts 1 and 2, there may be a determination made as to whether it should stay within the 7th District or without. And I would reconsider the ruling if we were looking at potentially moving within the district. So for purposes of where we're at today, I'm not considering it, but your point's well taken there.
All right, and Judge, so at this point, I would reserve my ability to seek a motion from the court asking that the court apply Mr. Bryant's report in the event the court moves this case from Fremont County, and it has to, at that point, under the rule, consider an appropriate judicial district.
All right, I'll just take that request under advisement at this time, depending on where we end up. So,
and I have nothing else for Mr. Bryant, Judge.
Okay, thank you, Mr. Bryant. Then that'll conclude your testimony this morning.